Bene, grazie a tutti di essere qua. In this joint seminar workshop between UNIDROIT and Italy, we're very happy to have so many people here, and also our researchers and staff members here. It is an honor and a pleasure to have here Professor David Hahn from Ilan University in Israel. He is arguably Israel's most important insolvency scholar. At least that's the one that those of us who do international insolvency law and read internationally is the one that we read the most. I'm particularly fond, I'm very fond of a lot of his work, but I have special regard to the beautiful paper, Velvet in Bankruptcy, that you once wrote, and that was so useful for our work on SMEs. So Professor Hahn is going to talk to us about the new law on insolvency that has been approved in Israel, which comes in very timely for us because of the European directive and the reform that is taking place in Italy recently, and perhaps even soon a re-reform here, and basically in every member state of the European Union. And I believe Professor Hahn is going to make also some sort of comparison with the directive, and so it'll be very, very useful. Monica, would you like to say something?
I just wanted to say welcome to David, and it's a pleasure to have you here. And it's very interesting for us to listen what you are saying about the reform in Israel, especially also because we know something already thanks to your contribution to the community of practice on the insolvency law. So we benefited from your answers to the questionnaires, and then this will also be an update to that part of our research project. So thank you again for being here. And as National already said, we are particularly interested in what is going on in Israel in this regard, also because Italy just passed a reform on insolvency law. And it's very, this is also an additional reason why we are very keen. Thank you.
So before I hand it over to Professor Hahn, just to say that the idea, I think, it's for him to give us a half an hour presentation, and then we all start a debate. This is an open debate between all of us, and put the reform to a test, and perhaps we can all learn from. So let's have a dynamic and informal, if that's okay with all of you. Please, Professor Hahn.
Okay. Does this work? Okay.
It takes a couple of seconds, I think.
Okay.
No?
So first of all,
No.
okay now?
Okay.
So thank you very much, Ignacio and Monica, for the introduction and for having me here. It's a great honor for me to be here. And of course, first and foremost, among friends that we collaborate and work together for several years already and know each other very well. As Monica said, actually, it's the international insolvency community, as I may say. And of course, we feel that the contributions of each and every one of us within the community, of course, enriches not only the practice, but the knowledge and the understanding of all of us in the international arena and in the domestic arena as well. And we try indeed to learn from one another. So it's a great experience to share the knowledge and thoughts. And I believe that in such a presentation, not only will I present the recent reform in Israel, but I'm sure that I will learn from the discussion following and from your comments and questions later. So I thank you in advance. Okay, and with that, if you allow me, I will stand up and present. Okay, so just to give a short introduction, let's start. Okay, I'm going to focus. I just spoke with Monica about it. We're talking about a whole comprehensive act in Israel on insolvency that was enacted just under a year ago. in March 2018 and will come into force this coming September. On September 15th this year, it will come into force. We had a year and a half in order to put everything in place and to adjust to the new act. But within such a large act, a comprehensive act, I'm going to focus first and foremost on reorganization, corporate reorganization and restructuring. I believe it is of interest here in the European arena as well. As mentioned by Ignacio, the new EC directive that is just about to be finalized, to get finalized soon enough. Of course, I haven't seen the recent and the complete version. The version that I'm aware of is the proposal from 2016, so I understand that it has been modified to an extent. So my apologies, when I will put up a table of comparisons, it will be based on the proposal of 2016, and of course you will know how to adjust. So just a short introduction. Until this new act, Israel's insolvency law was based on British mandatory ordinances, legislation before statehood of Israel. Israel got its independence in 1948, and before that, the land of Palestine, from the end of World War I until 1948, was governed by the British regime, and they enacted many domestic acts based on the British law of the time. So we had two major pieces on insolvency. One was the bankruptcy ordinance, which governed individual bankruptcies, and within the company's ordinance, we had legislation pertaining to corporate liquidation, among other corporate law, but only liquidation. At the time, the British did not have any legislation, as we all know, pertaining to reorganization. However, in 1995 and afterwards, we looked more over to the US and tried to learn from the US how to legislate and how to carry forward practice of corporate reorganization. In order to do that, we amended our Companies Act, which replaced the Companies Ordinance later, and we enacted there a minor part dealing with corporate reorganization. Actually, what we dealt with in the 1990s was only to insert into the law the power of the court to issue a moratorium order. And with that, to try to move forward and to rescue the company with some negotiations with the creditors. Later on, in 2012, as I will show later, there was another amendment of the Companies Act, which enlarged the legislation on corporate reorganization, and we inserted even a class act, a cross-class tram-down provision and other provisions, but we'll see that in a bit. So basically, when we compare the liquidation and reorganization schemes prior to the new act, we see certain differences. The main difference with respect to moratorium is that the liquidation, of course, the moratorium caught only unsecured creditors, excuse me for the typo there, and in reorganization, of course, there's a comprehensive moratorium that enjoins all creditors, including secured creditors, from enforcing and touching corporate property. The appointment of trustee in liquidation, of course, there's an appointment, a mandatory appointment of a trustee, a liquidator. In reorganization, the law never specified that there must be a trustee. It was left for the discretion of the courts. That's pre-2018 Act. We'll see what happens later. But the courts were so used to appointing trustees in liquidation or receivers in corporate receivership that invariably they appointed trustees, and they never even thought about the alternative, like the Americans, of managing the corporation through a debtor in possession. They did not do it. I can count on one hand, perhaps, the cases that they did. And even that's too much. Of course, there's a different goal, as we know, and the means, that's important. In liquidation, you have, of course, a liquidation sale and then just the distribution of the proceeds among the creditors according to the priority order. In reorganization, actually, we have a vote of the creditors and classes and then a court confirmation. However, when we talk about reorganization, what do we actually mean? We speak a lot about reorganization, but actually we can find different styles, I would say. Not necessarily legal forms, but different styles, business styles of reorganization. One style, which dominated the Israeli market before 2009, was the sale of the company as a going concern to a new controlling shareholder, basically a new investor who buys the corporation mostly free and clear of its claims. Whatever it pays, that is being used as the proceeds. The proceeds are being used for distribution to the creditors, and it continues the business free and clear of its pre-insolvency claims. It can be an asset sale or a stock sale, whatever. Then, from 2009 and on, we have a shift in Israeli practice to an extent. It's not that we don't have any more sales of businesses as going concerns, we have that as well. But for the first time, we have recapitalization, refinance in large corporations instead of selling to a new controlling shareholder. There was negotiations with creditors, swaps of debt for equity, and so forth. And the reasons that the market, that there was a change in the market is a result of two things combining. First, there was the first time an entrance of corporate bonds into the Israeli market. It's surprising, but up until 2000, 2001 or so, there were hardly any corporate bonds issued in Israel. The capital market in Israel issued primarily stock, and the only bonds found in the market were basically government bonds. And through the first decade of the new millennium, we have issuing of corporate bonds. Of course, corporate bonds are more amenable for negotiations upon the financial difficulties of the issuing corporation. And with corporate bonds, you can negotiate a swap for equity or deferring payments, installment payments, and so forth, not necessarily selling. The second factor was the global financial crisis. Due to the global financial crisis, the banks in Israel shrunk the availability of credit in the market. Once you shrink the availability of credit, you hardly have any purchasers of distressed companies, because the purchasers in sales of going concern businesses also financed themselves through debt. But when you have no supply of debt from the banks, it's hard to sell. When it's hard to sell, you have to negotiate with your existing creditors. So that's how we get to debt arrangements and so forth. Okay? But what we had on the other side is that the market was very, very concerned about reorganization procedures. It was understood in the market, not necessarily so legally, but the psyche in the market was that if you enter formal proceedings, even for a reorganization in court, that's a bad thing. It's a bad thing. It's something that hits the company for a second time. It takes off value and so forth. So everybody tried to work around formal court proceedings. Also, it was noticed that in court proceedings, as I mentioned before, there's basically a change of control. Because when you don't have a debtor in possession, when you appoint a trustee, so basically the management, the board, and on top of them, a controlling shareholder, they're all out of the game, and you have a professional, and no one wants to be out of the game completely if they can work around it. So they try to work around it and not go into formal court proceedings. Now, there were two, I'll skip this one, there were two initiatives that followed the global crisis in Israel, there was an outcry in Israel once we had a wave of debt arrangements in the market. There was an outcry in public opinion who weren't accustomed to such debt arrangements that something here is wrong. Why? Because in certain high-profile debt arrangements, we saw that in the end, the controlling shareholder remained in her position as controlling shareholder. And some said, this cannot be true. It doesn't make sense that the controlling shareholder remains there while the creditors are being paid less than 100%, where there are financial haircuts. It doesn't make sense. It's not right. Someone is abusing the others. The controlling shareholders are probably abusing the bondholders, and the bondholders, well, that's the outcry. It's all of us. It's the pension savings of the entire public, and of course, something has to be done. There were no empirical evidence whether this is really such a major factor in the pension savings. Nonetheless, you need some outcry, you need some negative press, and the government is squeezed to do something. And then they did two things. One, in 2012, we amended the act, the Companies Act, and we required that in any debt arrangement, there will be appointed an expert that will check, examine the proposed debt arrangement, and the expert will opine on the debt arrangement, the proposed debt arrangement. Without the opinion of the expert, there will be no vote among the bondholders on the debt arrangement. This, again, was very, very controversial because on one hand, it's supposed to support the bondholders. On the other hand, it draws any discreet, quiet negotiations into the public arena. Everybody knows about the appointment of the expert. It's an appointment by the court. It goes public. And whenever you had like closed boardrooms, discussions about a debt arrangement, bye-bye. Now it's public with all the focus on it. The other initiative was a year later. The government appointed a public committee chaired by the then General Director of the Ministry of Finance, Ms. Yael Andren, and it's known as the Andren Committee. And they wanted, the government wanted the committee to examine the whole issue of debt arrangements and make recommendations. They felt that something is wrong, not necessarily so, but that was the feeling. We need new recommendations. Problem is, the committee members were financial regulators only, and there were no insolvency practitioners or experts on the committee. That will, of course, affect the outcome and the report of the committee, as we shall soon see. These are the main recommendations of the committee. It's important because these recommendations have been inserted into the new act, and to an extent, this can draw some comparisons to the proposed EC directive. That's why I'm trying to focus on the Andren Committee and how it was translated into the new act. So, within the committee, they were searching for certainty. I appeared before the committee. I was not part of the committee. I was not a member of the committee. I appeared before the committee and I said, problem is in life you don't always have certainty. But we want certainty. They want certainty. They want everybody to know there are rules to the game and where you stand at every point along the process. Okay, so how do you do that? So one of the members said, we have to find a magic stick or a golden certain line that once you pass it, you're in a different ballgame. I don't want any gray areas, he said. It's interesting, by the way, it's a nuance. That guy who was very adamant in the committee. In his military service, he was an Air Force pilot. And I said to myself, oh, that explains everything. Our whole insolvency law is influenced by a pilot, because pilots are very, very exact. There are no gray areas. It's either here or there. You have to be at a specific second upon a specific location. That's the way they think in life. So that's where he took the committee. Okay, so what did they do? They said, oh, we have a very simple way how to draw a line. Let's differentiate between companies who have not defaulted, they made all their payments up to date, and those who have defaulted even once. Once you have a payment default, that's a very specific and certain event, and that will draw the line between the white area and the black area, okay? Stage one is the white area. Any company who has not defaulted yet on any of its payments will be allowed to negotiate freely between the company and its creditors in order to reach a business restructuring plan, a debt arrangement, whatever you want to call it. However, once you default even once, okay, then you automatically shift to the black area under the recommendations of the committee. And then they mandate the indentured trustee, they require the indentured trustee to turn to court and to file on behalf of the creditors an insolvency petition with the court within 45 days after the payment default. It's required. It's mandatory among indentured trustees with an opt-out. A supermajority of 75% of the bondholders in a bondholders class vote may waive that requirement. But other than that opt-out, it's a mandatory requirement. So those are the recommendations of the committee. Now let's move quickly, because I don't want to spend too much time. Let's move into the act that was enacted, and we'll see how it works out. Okay? In the new Insolvency Act, we did something completely different. First of all, comparing to the current legislation, we differentiated, like the British, between individual bankruptcies and corporate insolvencies. Here, we have the whole insolvency regime in one comprehensive act, both individual and corporate. But I'm not going to talk about the individual, we'll talk about the corporate. Within corporate insolvencies, we have two parts in the act which deal with corporate insolvencies in different channels. We have Part 2 and Part 10. In Part 2 deals with formal insolvency proceedings, both liquidation and reorganizations. Okay? So whatever we had before in the company's ordinance pertaining to liquidation, and in the Companies Act with the moratorium for reorganization, all that is now packaged, and you can find it in Part 2 of the Act. Then, in Part 10, we have an informal scheme for corporate reorganization, out of court corporate reorganization, or mainly out of court, not exclusively, but mainly. So let's compare the two quickly, and we'll see how it works. Well, if we talk about Part 2, the only major reform that we had here is that, unlike the British and American style that we had before, where you file a petition either for liquidation or for reorganization, you specify which process you want to enter into, we followed here the German format in their insolvency legislation of a unified petition. You file a petition for an insolvency proceeding with the court, and then the court will take it either to liquidation or reorganization as it finds it the case fit. There's a requirement for insolvency, and one important addition or change, there's a mandatory requirement of a trustee, both for liquidation and for reorganization, because it's a unified process. So if before we had the discretion by the courts whether to appoint a trustee or not, even though they hardly used it, now they cannot even think about it. They must appoint a trustee. There is indeed a provision which allows the court to leave management as they're in position, provided that there's another trustee appointed by side by side with the management. So basically, you may have the management, but there's always a trustee on top, unlike the American style. So that's part 2, with the moratorium and everything, nothing really new.
Sorry,
Part 10 is the new one.
just for clarification,
Sure.
the debtor under the trustee, would the debtor be fully removed or would it just controlled?
That's a question that the court will have to interpret. I think, as I read the wording of the new act, that the trustee will have the ultimate word. The management will have to coexist with the trustee, but the trustee will have the upper hand. And also the trustee is appointed by the court and it always can file a motion for orders from the court. So I believe that indeed the trustee will have the upper hand. Now comes part 10. And within part 10, there's a new scheme. And this scheme is based on the recommendations of that Andron committee that I mentioned earlier from 2013, specifically on the first stage of the committee, meaning a stage of prepayment default, when a company has not defaulted yet. We named this new scheme Protected Negotiations, okay? And it goes as following. This scheme can be commenced exclusively by the corporate board. Creditors cannot initiate such a scheme. They can ask, they can pressure, whatever, they can try to influence the board. But formally, it's only the board that commences it. It's an out-of-court scheme, at least in the beginning. And the requirement in order to commence the scheme is that the board will confirm and make a statement that A, it has not, the corporation has not did not suffer any payment default up to date, and B, that it is not, there's no material risk for a payment default within the next 9 months. Already practitioners are questioning whether such a statement by the board is practical. Which board will dare give such a statement and, of course, expose itself to liability for false statements and so forth. But nonetheless, this is the eligibility requirement for this scheme. Okay, by the way, if you can compare it to what I said earlier about the Andron Committee, the Andron Committee never talked about 9 months going forward. It just spoke about payment default, yes or no. This is a late addition by the Ministry of Justice. No one really understands why. There's some thought and philosophy behind it, but if I'll have time, I'll talk about it later. But these are the rules of the game right now. If you initiate the scheme, what the board should do is send notices of the commencement of the scheme to every creditor it wishes to negotiate with, and with that notice, basically, you start the process. Then the creditors are entitled to appoint an inspector. They will appoint a representative of the creditors that will serve as an inspector within the corporate board. It won't have any voting rights there, it's not part of the board, but it's eligible and entitled to sit in all board meetings and report to the creditors what is going on for the entirety of the process. The process will, it's probably in the next slide, the process will be for a maximum period of 6 months. Okay, for 6 months, no longer. Soon we'll see it's actually going to be even much shorter. Now, what is the protected part? We're speaking about protected negotiations. So there's a negotiation taking place here between the corporation and the creditors. Where's the protection? The protection is here. During this process, the creditors are prohibited from accelerating payments under any acceleration of payments clause, even if they have it. They cannot enforce their rights, okay? And they cannot file for formal insolvency proceedings in court while the negotiations are taking place. And the third protection, which is not here, the third protection is that during this period, only the corporation has the exclusive right to present a plan, a reorganization plan. It's taken from the exclusivity period of the U.S. Chapter 11. Only the corporation may present a plan during this period. No creditor may place a competing proposal for the time being. So that's the exclusivity, and as I mentioned, 6 months. However, notice how you can shorten the period from 6 months. It may be shortened to 45 days from the occurrence of an acceleration covenant, meaning if you have in your debt instrument a covenant that, absent this scheme, would entitle the creditor to accelerate at that point the payment and enforce its rights. Although the creditor may not do it at that point because of the protection of this scheme, it may nonetheless trigger a shortening of the period of this scheme to 45 days from that point on. Which means practically, since they did not insert a prohibition on ipso facto clauses, there will probably be in all debt instruments, at least at the beginning, ipso facto clauses that will probably provide that any inception of this scheme will constitute an event of acceleration. Of course, you cannot accelerate at that point, but from that point on, you have only 45 days for this protected scheme and not 6 months, which of course shortens the period and puts a gun on the table in front of the board, 45 days, and afterwards we can take it to court. So that's a bit too pressing for free negotiations. Then, to the extent, and assuming that we passed all these obstacles of such covenants and the statement by the board, and this process goes forward well, the thought is that the product of this process should be a reorganization plan presented to the creditors for their approval, probably as a practical matter for the approval. Then you will file a motion with the court in order to enjoy the majoritarian vote that you have under a court-processed insolvency proceeding. Because outside the court proceedings, you need the approval of each and every single creditor. Under the court, you can have a majority vote that will, of course, apply to all creditors, including the cram-down provision. So you can have even the interclass cram-down vote and approval of this debt arrangement as the product of the protected negotiation scheme. So to sum it up, I want to make just 2-3 comments, and then the table, the comparison table, and then open it, of course, for your comments. First of all, you can sense that we're somehow following, to an extent, certain similarities and steps that you can find in the UK scheme of arrangement, and also, I believe, in the European proposed directive that tried to, of course, encourage corporations to work out their problems outside of the formal court proceedings, not necessarily with appointing a trustee, but rather by a management-driven process and direct negotiations between management and the creditors. On the other hand, this non-payment default trigger is, I think, something unique. I cannot find it in other proposals. I did not notice such a provision in the proposal in the EC directive. That is a sharp line that you cannot step beyond. It's definitely not like that in the UK system. Sometimes in Israel we quoted the UK scheme of arrangement, but the UK scheme of arrangement can be used even if the corporation is insolvent, deeply insolvent. So this trying to start the scheme way ahead of insolvency and any cash flow problems 9 months in advance, that's a barrier only of the Adrin committee. I'm not aware of it in comparative law. If you know of any, I'll be glad to educate myself. And this is a table in which I try to compare, first of all, the left-hand column is the full insolvency proceeding under Part 2 of the Israeli new Act, of the 2018 Act, where you can have reorganization supervised by or ordered by the court, and then have a protected negotiation. And sorry for the colors, but I'm trying to, how do we go here? Oh yeah, here you see this green colors are pointing to the advantages of the protected negotiation compared to Part 2 with the full-scale court-ordered proceeding, because here the commencement is exclusively by the debtor, so that's an advantage for the management, that no creditor can place it there, and also it's controlled by the debtor, not a trustee, and there's definitely an exclusivity, whereas there's a question mark whether there will be exclusivity under Part 2. It's not clear from the statute. So it seems more friendly for management, but on the other hand, as we stated, the statement by the management of 9 months forward is an obstacle. Also, you will have to report it because it's for listed companies only. Listed companies, this is an event you have to report under securities laws, so it won't be so discreet as someone thought in the beginning. And eventually, I'm trying to compare it here in the third column with the EC proposal, and we can see certain similarities, but not all of them. For example, here, only the debtor, no trustee. Here, if there's a stay, a formal stay, you will have probably a trustee under the proposal. And here also, of course, the commencement may be with the creditor, with the debtor, consent that the creditor can act. But other than that, you can find certain similarities, especially in the sense that you have a free negotiation without the court ordering every step along the line, and it ends up in a class vote with cram down in all the different regimes. So there are certain similarities, yet it's not one by one identical. And of course now I'll be glad to hear your comments on this new scheme in Israel, which, as I said, is completely new under the new act, and many in the market have a lot of question marks and critiques. Is this indeed going to work or not? One last comment before yours. One of the interesting things that I skipped, as you can see, I have a line for executory contracts. In Part 2, obviously, as a court-driven insolvency proceeding, you have provisions for salvaging executory contracts, assuming executory contracts, and so forth. In the protected negotiations scheme, we don't have that. And it's because the protected negotiation scheme was designed based on the holding corporation with bondholders, only financial creditors. No one thought about industrial corporations with suppliers and service providers and so forth. But what can you do? You have listed corporations who are also industrial corporations, not only holding corporations. And if they issue bonds and they have bank loans, so they have both financial creditors, but also suppliers and employees and all those types of creditors. And it's a big question mark. How can you move forward a reorganization effort for such industrial corporations without trying to deal with their executory contracts? I'll stop here and I'll be glad to hear your comments. Thank you.
Thank you. Thank you. Thank you. Now, okay. I don't know. I have many. This is very interesting. Thanks a lot. I would have many questions and perhaps 2 or 3 remarks, but I'd be happy to give the floor to whoever would like to.
Thank you very much, David. And the first thing I was noting, and probably my colleagues from the bank also pointed to that, is the fact that also in Israel this new reform is having a long vacancy wages of 18 months, and we have the same in our reform, and we were a little bit surprised to see this long period before the law is coming into force. Probably in the case of such radical reforms, it's important to have some time to adjust and also to try see if certain new tools can be effective, or if all the interested parties are prepared to use them and so on. But in our perspective, as a message to investors, it's a bit strange to see that there will be some changes that won't be effective before 1 year and a half. But I think it was really interesting to see that in another country, same time, a reform enacted almost in the same year, also followed that approach.
You know what the vacation is the German law? 5 years.
Yes.
It was approved in 1994 and entered into force in 1999.
And actually, in Israel, the 18 months delay was first, the most important part was to allow all the government and judicial units to adjust, because within this new act, I touched upon the corporate part, but in the individual part, there are certain important reforms that require time to adjust. The most notable one is that we have a jurisdiction reform. In Israel, you have 3 layers of courts. You have the magistrate court, then you have the district court, which is for certain matters a court of first impression, and for other matters, it's the appeals court for the magistrate court, and then you have the Supreme Court. Under the British law that we had up until now, all insolvency cases, individual bankruptcies, corporate liquidation, corporate reorganization, they were all as a first impression matter in district courts, not in magistrate courts. And now this act takes all the individual cases, the new individual cases that will take place under this act, and moves it to the magistrate courts, and the corporate cases will remain in the district court. Now, the shift from one court to the other requires a lot of preparation, educating the magistrate judges, and certain modifications of the computer system of the judicial branch and all that. And for that purpose, they said, okay, take 18 months and adjust.
This goes to the second question I had, because I was wondering whether in your system there are specialized bankruptcy courts. Now you are saying, if I understand correctly, that this reform also improves specialization of courts, because or it was already in the system that certain judges need to be qualified to.
It's informal. I mean, in each layer, both today in the district court, in each of the 6 districts in Israel, there are no formal insolvency judges, but practically in the day-to-day management of the court, there are designated judges who deal primarily with insolvency cases and thus gain expertise. Now, when they ship the individual bankruptcies to the magistrate court, they provided in the law that in each court there should be designated judges, not necessarily for life, but for a certain period of time that, of course, the president of that court will determine, that will be experts in individual bankruptcies and deal with those cases.
I don't know if there are questions. I have one more concerning the distinction between this full insolvency proceeding, which can result either in a reorganization or liquidation, and the protective negotiation. Question regarding the triggers for the two proceedings, because you said earlier that there is a clear line between cases of default payment, and then in such case the debtor has to file a petition for insolvency, and no default payment, then only in those cases a protective negotiation is possible. But here in this summary you wrote that one of the requirements for a formal insolvency is likelihood of insolvency. So my question is, would the in case of balance sheet insolvency without a default payment yet, which probably would be the case considered by the law when it allows for protective negotiation if a default payment is envisaged in 9 months forward. But as to the requirement for a full insolvency proceeding, is prospective insolvency so independently from a default payment or not? So it's a bit less.
Absolutely. They were searching all the time for the definite line. Nonetheless, there's a general definition of insolvency for the entire act. Either a cash flow insolvency or balance sheet insolvency, whichever. So if, like you suggested and asked, if there's a balance sheet insolvency, even though the cash flow is still fine, the company is insolvent. And of course, any of the two, either the management of the debtor or any of the creditors, may put it into formal insolvency under Part 2, unless it's somehow squeezed already into protected negotiations. For that period, the creditors won't be able to do it. They'll wait beyond the corner, but at that period they won't be able to do it. But under the law, yes, that's insolvency for the purpose of filing other parties.
So in this respect, it's in line with the international practice.
So this seems like the legislator wanted to mirror the schemes of arrangement, but the practice said we are going to go only halfway, because the schemes is basically the only system which has first a hearing on the formation of classes and then another one on possible challenges. And here you have that, but then at the end the judge said, no, we'll all look at it at the final hearing, right? So it's quite interesting. I was just, a few doubts, but not to leave this topic and linked with it. Is there a criterion for class formation that's mandatory? So, for example, based on the directive and the way we incorporate it in Spain, for example, there has to be a criterion which is the economic value of claims as they would be in a formal insolvency proceedings. That means based on their hierarchy in insolvency. So I can only decide to form a class of the Bank of Italy creditors here if they hold claims that are economically worth the same. Otherwise, I could not keep them in the same class, of course. And so, would that also be the case?
Yes, that would be the case in Israel. The statute provides that you should classify claims of creditors that are similar to one another, similar in their interests. What that means has been interpreted over the years in case law, and the courts have indeed interpreted it to require classification of only claims who really share the same priorities and are treated similarly under the plan. If they are treated differently, you should separate them into separate classes.
And which would lead me to finalize on the classes part. What would be the treatment of equity? Do you create a class for equity as well? We classify equity holders if
if the court finds that there is only a cash flow insolvency. If the court reaches a conclusion that the company is balance sheet insolvent, then basically the shareholders are out of the picture and you don't require their vote. So first of all, you need to have a valuation by the court of the state of the corporation, balance sheet wise, in order to determine whether the shareholders are entitled to vote as a class or not.
Because so shareholders are underwater and therefore they count not, and they can be written off and yeah. But so I imagine you have an absolute priority rule. See, that's what changes with directive, and in part in part at least only due to the work of this project where Bank of Italy was part of and other universities. So the inclusion of a relative priority rule in the European directive was precisely aimed, at least in part, to allow in those situations in which shareholders had added value to be able to be granted some value upstream. And therefore, there is an absolute priority rule, but also a relative priority rule as a possibility in the European directive. Precisely because otherwise, especially in those types of businesses that where the persona of shareholders is relevant, you want them on board. You need to offer them something, otherwise you just won't negotiate.
In the practice in Israel, indeed, in the first wave of debt arrangements, as I mentioned earlier, controlling shareholders remained involved in the corporation even after the arrangement was approved. So basically, within the arrangement, there were provisions that allowed the shareholders to remain with a stake in the corporations, provided they invest either cash, new value in cash, or in other equivalent economic values such as know-how, management, and so forth, which is very, very tricky and very dangerous, but nonetheless, there were provisions and certain such arrangements were confirmed by the court. So even though we do have the absolute priority rule as the benchmark of the law, sometimes within consent between creditors in their classes and shareholders, they may reach a deal in which the shareholders do remain with probably a lower stake, a smaller stake than the one they had when the company entered the scheme, but nonetheless, they're not ousted completely. By the way, if we mention this and thinking, once you mentioned absolute priority and relative priority, it's worth noting, perhaps telegraphic, because I can't cover, of course, the whole act in such a short time, but there are certain other additions and reforms which will be very, very influential in the market in this new act. Saying telegraphic, no, we don't use telegraphy here, but since I wandered through the streets of Rome and I saw ancient monuments such as public payphones, then you can speak about telegraphic as well. 2 points in that context. One is, just like the proposal and just like the British system, there's a new provision in the Act which we did not have before about directors' liability in insolvency, which creates a very, it's a scare for all the boards in Israel. Any board which hears about it is put immediately on alert, and they say, how do we deal with this? We're used to a certain liability that we have under the Corporations Act. What is this new liability, and how do we, of course, balance between the two? It's a good question, but with respect to priorities, there's a major reform in the priorities under the new act. We have in Israel, as we inherited the British system, the concept of a floating charge, aside from a fixed charge, a floating charge over all the corporate assets. And just like a fixed charge, the floating charge always enjoyed an absolute priority over unsecured claims. It was subject to certain statutory priorities, but just like the British system, but it was always absolutely in priority over unsecured claims, 100%. And in the new act, there's a carve-out from the floating charge of 25%, which is huge. 25% of the value of the assets subject to the floating charge that will be carved out of the floating charge in favor of unsecured claims. So the floating charge will enjoy a priority over unsecured claims of only 75% of the value of the assets, which of course for the banking industry means, and all the banks are already modifying their loan documents, that they will require higher LTVs, loan to value, and require a larger value of collateral for any loan based on a floating charge, so that even if the worst scenario arrives and there's insolvency, after the carve-out of 25%, they'll still be covered because it's 25% of the assets, not of the secured claim. So if for example, you take 400 euros worth of collateral for a 300 euro loan, then after you carve out 25%, you're still covered 300 for 300. So the fact that there's a carve-out doesn't necessarily mean that the floating charge won't be able to cover itself. It only will adjust the LTVs. The thought behind it was to leave something for the unsecured claims, who usually recover a minimal amount. So this will probably force for a larger recovery for the unsecured claims ex post, but ex ante, of course, it will completely change the landscape of the financing terms of the lenders. There's no question about it.
This is very interesting. So this would push for over-collateralization, but not...
And personal guarantees.
And personal guarantees, of course, but probably not from the point of view of floating charges, because if floating charges are designed as the English ones, they already cover for everything you have. So, I mean, unless you're altering the valuation itself, you can cover more than all you have is there, so you can't really... But what it would probably push...
It will reduce the value that you lend. I mean,
exactly, it would push down the lending,
exactly,
the great availability.
Exactly.
Or it would force, because floating charge would be over inventory, but not over fixed assets, right? So it would push banks to require fixed assets as collateral for full debenture.
That's what we expect.
Sorry to continue. I have a couple of points on this. This is all very interesting, at least to me. From the chart that you have there, while on the one hand not having any effect on executory contracts would seem not a good idea, because you need to act on, if you want to restructure, you need to act on executory contracts, and you need to keep them in place. But the truth is, it's relatively consistent with the fact that you can only access that procedure if you have not defaulted. So therefore, executory contracts will most likely be running anyway. So, so in that sense, it kind of makes sense.
That's right. That's a counterfactor.
What worries me more about that is, if I understand it correctly, that you don't have any priority for financing of restructuring agreements. And that is a huge problem.
In the protected negotiations, yeah. Because in part 2 we do have, and you're right.
In the protected in the out-of-court thing.
Right.
Without that, no one is going to be willing to lend.
That's right. In the full-scale insolvency proceeding under the court, we have provisions for priority for fresh financing. And that, again, was overlooked in the protected negotiation scheme, which is a major disadvantage in carrying forward this scheme. And of course, you have not defaulted yet on payment, but that doesn't necessarily mean that you're rich in your cash flow. And you probably, in order not to default, you may need some fresh capital, fresh financing, and without such a provision, once you're in such a scheme and you have reported that, because it's for listed corporations and you reported that, who will lend? Yeah, it's a major disadvantage. You're right.
That will have to change probably.
Oh, yes, definitely.
Well, two final questions from my side, sorry. From looking at the whole picture that you so skillfully portrayed, it looks like your legislator had in mind large entities, and you know, the fact that the no default rule only makes sense if the corporate is a large corporate. It definitely will never happen in the case of small entities. It also explains the reference to corporate bonds. Actually, many countries don't really have a rule to restructure corporate bonds. So that's quite advanced, and you had it before already. So that's a good point there. But that leads me to two questions. First of all, and apologies if I missed it, I think you didn't define it. Would this protected negotiation procedure cover all creditors, or who are the relevant participating creditors? And the one on the second one, and to finish, shouldn't I mean, or perhaps there is already, but wouldn't it make sense to try to provide for a framework to solve viable but small entities? Because with this law, it seems like it might not be covered. I imagine it would be over 90% of the cases, like everywhere.
Yes. Great questions and great challenges for this new framework. Indeed, as I said, the focus and probably the model corporation, which the legislature, and even before that, that public committee which designed these stages, they had in mind the model of the corporation with only financial creditors. A large corporation, mainly holding corporations that have the bonds, they have bank debt, but nothing other than that. They are probably holding stock of industrial corporations, either small or large. But that's not your average case, and that's what we try to argue. Take into account that this may be okay for such corporations, but it's probably impractical for the other corporations. And I try to convince the Ministry of Justice, as official receiver, the legislative branch, which is a separate branch in the Ministry of Justice, I try to convince them that if they want to put in place this scheme, they should limit it only to holding corporations with financial debt exclusively. Then it may make sense. But to not to limit it to holding corporations and to expand it to all listed corporations, I can now list a long list of Israeli listed corporations on the securities and bond market who are industrial corporations with employees and suppliers, and it doesn't fit those corporations. It's too sterile for such complex restructurings. And as you mentioned, for small corporations, it's definitely not going to work, and everybody understands that. And what can I say? I think that's something that we have missed upon, that we did not design something that may be more applicable for small, medium entities with their specific traits and with their specific challenges with smaller creditors and traditional founding shareholders and all that bunch. We just placed them in the general part 2, which may work, but as we saw in British law years ago, they have thought about the small corporations separately than the general large industrial corporations, and it does make sense, but maybe that was something that will be amended later on down the line. For now, we don't have it.
Yeah, you already answered one of the questions I had, which was on the fresh finance, but Nacho raised the point. Again, on the categories of creditors that can be involved in this negotiated scheme, is it possible for the debtor to, but probably you already answered now to that, is it possible for the debtor to negotiate only with certain group of creditors, meaning financial creditors? So this is linked to...
Right, yeah. Ignacio already mentioned it, and thank you for this
which would be
issue.
in line with
Sure.
the British scheme already.
This is something very interesting, perhaps even tricky in the protective negotiation scheme, because as it was legislated, the protective negotiation scheme works between the corporation and each creditor that the corporation chooses to negotiate with. Meaning that if there are certain creditors that the debtor corporation does not wish to include in this scheme, they will be left out. They will not be negotiated with, and this scheme will not apply to them, which sounds somewhat strange, to me at least, because of course you can do that, but if you're going to a selective scheme, then I raise the question, why do you need legislation at all? Because usually, if I choose to negotiate as a debtor with 3 or 4 of my creditors, for example, and they are willing to negotiate with me, because if they're not willing to negotiate, then I can try, but we won't make any progress. Now, if they're willing to negotiate with me, do I need any legislative protections, or will that not be part of the practice of a standstill agreement between me as a debtor and those creditors? They will agree that for the process of negotiations, there will be a standstill, and no one will enforce their rights. Usually, we need the stay or the moratorium probably to protect us from non-negotiating, non-cooperating creditors. If they are all cooperating, it's nice to have the statute, but we can reach that even consensually without the statute. So having a protection only for those creditors with which the company has chosen to negotiate, and in parentheses, probably have agreed to negotiate with the company, those creditors, it's a nice statute, but we would do it under agreements anyway. It's more important to have a comprehensive scheme where all creditors are included and enjoined from enforcing, but that's not how it was designed.
So other creditors are not informed or notified about the fact that
right. Well, that's how they legislated. We have to see how it will take place in practice, because perhaps in practice companies will choose to negotiate with all the creditors without differentiating, and then maybe it will be comprehensive, but we'll have to see how it works out.
I have one final question, and sorry for taking the floor. As you mentioned, financial creditors, and we're talking about also the fact that who will lend if there is no protection for banks and so on. I had a question on whether in Israel you have something like the London approach, as much of your insolvency law was derived from the British system. So if there is a form of organization or some code of conduct by banks, that there is a way in which they can solve the problem of coordination that financial creditors also have in negotiating with debtors.
That's a good question, a good issue, because I'm not aware of any existing arrangement or whatever, or protocol between the banks. By the way, we don't have too many banks in Israel. I mean, we have 5 major bank groups two of which are like a duopoly, Bank Leumi and Bank Hapoalim, the largest two banks in Israel, in the reverse order. And there is no specific and no formal protocol like a London approach, even though they usually try to negotiate amicably with corporate debtors before going to formal insolvency proceedings, and sometimes they are successful. The interesting thing is that from a completely different angle, they are also concerned to form such a protocol. And that is because the antitrust body in Israel, the antitrust regulator, deems such protocols and so forth as coordinating between banks as anti-competition, which to me strikes as very odd. This is no anti-competitive move. This is not anti-competition between the banks. This is basically trying to coordinate to salvage value upon a crisis. And the whole philosophy of insolvency is a collective proceeding for creditors. So if you don't allow the creditors to communicate and try to form solutions among themselves, what are we doing in insolvency in the first place? It's very odd. And I'm trying to explain that to the antitrust authority so that they will lay off, because they're striking and they're pushing the wrong button in my eyes.
I think you could draw some further comparative help from your persuasion, looking at something which is actually more complex than that, which is antitrust law in the European Union and how public creditors are allowed to vote in favor of a write-off. Because initially people thought that was state aid, and therefore it was forbidden under the European antitrust system. And the final decision of the European Court of Justice, which is now clear everywhere, is that so long as the public creditor votes based on economic rationale, that's not regarded as state aid. It's just behaving as an ordinary private creditor who takes the best decision for its own claim. So
pursuing an economic interest.
yes, it's your own economic interest and the economic interest of the collectivity. So therefore, there is no antitrust problem at all. But so if you have 5 banks, then you have the best possible world for restructuring, because you don't really need anything, because they probably know, the same 5 people sitting down in every table, they know each other. They don't even need to sign a standstill agreement, because they know, they would make an analysis and say, well, this company is viable, or if it's not, let's just all try to seize as much as possible. But if it is, and that should be always the entry gate to a proper restructuring, if it is, it's in the interest of all of us not to destroy the value. So why have a law? But because the law, and this is the last point, this is where the problem might come in through the back door. The law, the moratorium on this type of effects obviously are included to prevent strategic behavior by holdout creditors. But who are holdout creditors? And this is when distressed debt funds come into play. And this is all over Europe now.
They buy them out.
They buy debt just to hold out these agreements so they can be paid in full. They buy at a discount,
right,
and they make a huge profit. And that's why you need a moratorium.
Yes, and we have that phenomenon in Israel in recent years as well. And you're absolutely correct. And by the way, yeah, it's true that of course, the managers in the banks of distressed debt and financially distressed corporations, we have divisions in various banks dealing with financially distressed corporations. They're repeat players, and they know each other, and they know how to deal with this. However, we're talking about Israel, and as we mentioned before, Nasi and I compared Israel to Italy and to Spain, culturally wise, okay? Unlike the rational Europeans, okay? Sometimes in Israel, you react irrational. And even when you speak about banks, because there are relationships between the bank managers and either the chair of the board or the controlling shareholder of large corporations. And excuse me for the language, but if, and we had such cases, if the controlling shareholder has pissed off the banking managers in the past and the relationship between them drew bad blood, there will be retribution when the company is financially distressed. And then maybe other lenders and other banks are willing to act and negotiate rationally, but there will be one large bank who will act out of retribution rather than logically and rationally, and then the moratorium is, even among the banks, very, very important. That's Israel.
Thank you. Among the very interesting things that you said today, one of them was that there's been a move towards bringing these cases more towards the magistrate courts rather than the district courts.
The individual cases.
Yes, and from where I'm from, which is Pakistan, you'd want cases of these types of individual cases to go to the high court, which is comparable to the district court, because of reasons of efficiency, because of reasons of getting better judgments. Why do you think it's beneficial for these cases to be moved to the magistrate courts, if I may ask? Thank you.
Sure. You want a true answer, of course. Frankly, it's because of the load on the court docket. There are so many individual cases nowadays that the district judges were more influential and powerful than the magistrate court said, we've had enough. This is too much. You need to help us. And they lobbied for it with the Supreme Court Chief Justice, who explained to the legislature the workload of the different levels of the courts, and he said, okay, so we'll move it to the magistrate court. Will that solve the load problem? Probably not. But again, in the hierarchy, the district court judges prevailed in their tryout. That's the truth.
You expect most cases to be appealed, though, right?
Yes, many of them.
Okay.
Anyone else? Well, yeah.
Just to conclude the discussion about the outcomes of the reform, I'd like to ask you especially, who do you think is going to benefit from the protected negotiation? Because you said we created the reform, but the reform was designed concretely to address problems about holdings and so on. So who do you think in concrete is going to benefit from the reform, or some tools, for example, the protected negotiation is going to be unapplied in concrete?
That's a great question. Only time will probably tell who is going to benefit from it. It's a wonderful question. I'm not sure how to answer it definitely. One group that I'm thinking of, but that group is kind of caught in between, are the board of directors of large-scale corporations, especially holding corporations. Because on one hand, this scheme may help them out in the sense that, as I mentioned before, that the new Insolvency Act imposes a new liability on directors of corporations, somewhat like the deepening insolvency concepts. In order to avoid the potential exposure to such a liability, perhaps boards of directors who can, of course, use this scheme, protected negotiation scheme, and apply it early, by that they may escape any potential liability that they may be exposed to later on. So that this may potentially benefit board of directors. On the other hand, as I said, they're kind of caught in the middle, because in order to enjoy this unofficial protection from a potential liability, they will have to state a statement of 9 months forward about the cash flow, and that potentially exposes them to a different type of liability. How will this work out for them? It remains to be seen. But that is one group that I can think of. The other group are controlling shareholders who are frank enough with themselves to understand that the corporation is basically deteriorating financially, and if they want to salvage their control and their investment in the company, they may invoke this scheme early on in order to devise a plan that will, of course, refinance the debt and still leave them in order before the company will go underwater and be in court where they will be out of the game. So potentially they may use it, although, again, I'm always trying to think of the other side, and the other side is always here psychologically. It's a psychological barrier that they need to cross, because they try and tend to convince themselves that give them some more time and everything will work out, it will be okay. And it's Israel, again. We're trying to delay everything to the very last moment. I don't know how it's in Italy, but I do believe that it's not that, not that different. But in Israel, yeah, we're experts of leaving everything for the last minute. So tell the controlling shareholders, you know what, you have 9 months in advance a potential workout that can solve your problems and, rescue your company, and you'll be left at the helm. And said, 9 months? Why are you turning to me now? Let's move on. So I think there's a potential there, but there's a culture and psychological barrier for them to using that advantage that is there for their at their disposal. So we'll see. I think those two groups are the potential beneficiaries.
Okay. Well, it only remains then for me to thank David Hahn very much for being here, and to all of you for coming. And please join me in thanking him.
Once again, I thank you for the opportunity. It was a wonderful floor and panel to participate in. And if any one of you, of course, plans or will plan to visit in Israel, please be in touch with me. You have my emails, and of course you can be in touch with me. I'll be glad to show you around and to have you for professional events and personal events, whatever. Okay, you'll be my guests, and please do take advantage of this invitation. Okay, thank you very much.
Thank you.